Good morning. Happy Thursday. Discussing law, TM, Dr. Law. Made another video. It's stupid. I'm not going to go over everything you went wrong on. There's two things that I think are interesting and somewhat important. Number one is analysis of the anti-slapp statute. His analysis of the anti-slapp statute would be correct if Massachusetts anti-slapp laws applied. Now, I don't know if you guys remember it, but I went over a Massachusetts First Circuit District Court case. Somebody sued Bill Cosby for defamation. The plaintiff was in California, and Bill Cosby lives in Massachusetts. And the court applied Massachusetts choice of law provisions and determined that the plaintiff's home state would be the basis for the defamation. The case law in plaintiff's home state, the statutes in plaintiff's home state would be controlling over whether or not there was defamation, etc. Part of that included California's anti-slapp statute. California's. And so Bill Cosby, a non-government agency, applied California's anti-slapp statute against some gal from California who is not a government actor and successfully got his case dismissed through California's anti-slapp statute, which does not require actions, which does not require the governor or any other state actor to be the one chilling the free speech or attempting to chill the free speech by filing a lawsuit or otherwise doing some governmental action. California's anti-slapp statute is different than Massachusetts. And because Chile is a plaintiff from California, assuming the court does the same analysis, the court is going to apply California law for defamation and California's anti-slapp statute. So there you go. And in addition, I also went over somebody sued Rachel Maddow for defamation. Rachel Maddow applied the California's anti-slapp statute. And again, she prevailed, even though the person who was suing her for defamation was not a government actor. So his analysis on the anti-slapp statutes is entirely wrong, unless you were applying Massachusetts law, in which case it is more correct. It's not necessarily 100% correct, but it's more correct. So that's the anti-slapp one. I'm going to ignore the rest except for his myth that he was busting about the organizer being responsible for the actions of the organization. Now, he went through some weird steps that I don't entirely understand. He tried to apply common law agency. At least in California, common law agency doesn't exist. Agency law, the principal agent relation, is defined by statute. It's in the civil code. And there are various cases that determine that determine when and where and how to apply that particular statute to a principal agent relationship. I'm going to assume, without knowing, that Massachusetts also has defined that principal agent relationship. I don't know why he's going into common law. I don't know which state's choice of law would apply. I assume it would be Massachusetts. So I don't know what their particular statute is. But then he starts talking again about crimes, and I'm trying to figure this out. And then it dawns on me. I'm not the brightest boy in the world, but he's talking about RICO. And RICO is one of these things that people don't get right. People just don't get it right. It is a criminal enforcement statute that has a civil enforcement mechanism baked in to the middle somewhere. So a private individual can sue another private individual or sue somebody else for a RICO violation. Now, there are various things that you need to have. And one of the most basic things that you need to have is a specific crime. RICO has a specific enumerated list of crimes that you could sue someone under the RICO Act for. And nowhere in there is harassment. Nowhere in there is harassment or intentional infliction of emotional distress or anything else that Chile has thus far alleged. There's no cyber stalking. There's nothing. The most common thing, the 100% most common thing that people sue for under RICO is wire fraud and securities fraud. Fraud is the number one thing. People pay their money. They were defrauded of their money, and the money crossed state lines. So the federal government has jurisdiction over it. Bada boom, bada bing, bada bang. You can sue for RICO. You can get treble damages. It's fun and exciting if you could do it. Now, there are a few state causes of action specifically enumerated in there, like murder, arson, robbery. Big boy crimes, right? Big boy crimes, not harassment. Harassment's not listed. So drug crimes, various drug crimes are in there. But it's hard to sue someone. It's hard to get a cause of action under a lot of those things. Well, I guess technically murder and arson, but drug crimes. He sold me a bad batch of GHB. I don't know. Anyway, so that's problem number one under RICO, is trying to figure that part out. Where do you get your cause of action, Chili? Like, what crime are you alleging? Now, the potential crimes he has alleged are harassment, stalking, things like that. Criminal harassment, criminal stalking. Now, I understand, I hope you understand, that California's choice of law on defamation would apply. But criminal law, Josh and Kate are in Massachusetts. The actions they took were in Massachusetts against someone who was currently then in Massachusetts. So Massachusetts law is going to apply. That's problem part 2A. Problem part 2B is we have adjudicated those. They have been adjudicated. There's 2 court rulings saying that what Kate and Josh did, or at least what, I think there's 2 for Kate, maybe 1 for Josh. But anyway, there's adjudications now that what Kate and Josh did not rise to the level of a crime, because you have to remember, in the Massachusetts HPO statutes, if someone commits stalking or criminal harassment, that is a basis for issuing a HPO, a harassment prevention order. Chili failed to get that. He failed to show by a preponderance of the evidence that there was criminal harassment or stalking. It's been adjudicated. It's done and dusted. He goes into federal court and he says, well, I got my RICO. They criminally harassed me. The judge is going to say, first of all, that's not something that you could do a RICO under, kid. You know procedure well, but you're not good on the law, or whatever polite way of trying to put it she's going to do. Second of all, it's been adjudicated. You've already lost on that issue. You're not going to be able to prove by preponderance. Now, if, for example, how would we do this? If she'd been charged with a crime that is a RICO crime. Let's say Kate had been charged with arson. Let's say she burned Chili's car or whatever, his van. Let's say that. Now, let's say that the court or the prosecutor had failed to prove that beyond a reasonable doubt, a high standard of proof. Chili would be able to still sue, theoretically, under RICO, provided he got the association and other portions of it down. But at least for the crime, let's just focus on that one element. At least for the crime, he would be able to prove that he would still theoretically be able to prove beyond a preponderance of the evidence standard that she committed arson. Maybe the state couldn't get it to beyond reasonable doubt, but he might still be able to get it to preponderance of the evidence. So just because she'd been criminally prosecuted and found not guilty would not, in my understanding, prevent her from having to be subject to the civil liability under RICO, because it's a lower preponderance, or it's a lower standard of proof. But it was the same standard of proof. So it's already been shown that it cannot be proved beyond preponderance of the evidence. So he's stuck on so many levels. He's done on so many levels. So again, RICO's stupid. This whole process is stupid. Chili's just flailing around with zero understanding of what he's doing. He's just flailing around. He's churning the water. He's paperworking the place. I just find out this morning that he has apparently been contacting the court ex parte, i.e. sending stuff to the judge without sending it to the parties. And the clerk was like, look, buddy, if you're sending it to the judge, it's going to be public record. We're going to go ahead and post it, chum. So anyway, no ex parte communications there, constitutional law scholar. Jesus Christ on a cracker. This guy's an idiot. Idiot. You're an idiot. And I don't know how, it's been like a week now or something like that. It's been more than a week, and I'm still a practicing attorney with a blemish-free record. Crazy. Now he's going after Arizona girl, Arizona Jeep girl, because apparently he thinks, number one, she's an attorney, and number two, that anything that she said in the comment section of a YouTube video is going to get her disbarred. This guy is smoking something, and it must be good stuff, because he's just... Anyway, I'm just rambling now. Thanks for watching. Have a great day.